Hi, I'm Clark Wilson, and I am a member of the Intellectual Property section of the State Bar of Georgia. I want to thank you for selecting this video, An Introduction to Intellectual Property Law. This video is the first in a series presented by the IP section of the State Bar of Georgia, designed to give an introduction to various areas of intellectual property law and how you can benefit from them. This video will provide an overview of the major components of intellectual property: copyrights, trademarks, patents, and trade secrets. Hopefully, my colleagues and I will be able to provide a little insight as to the rights associated with these four areas and answer some basic questions. First, we will turn to Lee Morin to discuss copyrights.
If you are a creative person, then you have probably heard of copyrights. A copyright is a protection offered by the federal government to secure your rights to your creative works. Creative works include literature, music, lyrics, plays, movies, video games, recorded music, architecture, dance routines, and works of visual art, like drawings, paintings, and photographs, to name a few. As long as you are the original author of the work, or you have permission from the original author to modify the work, then you may be eligible to own a copyright in your creative work. Owning copyright means you can exclude others, including people and businesses, from using your work without your permission. It also means you can monetize your work by granting permission to certain people and businesses to use your work in their projects. There is much more to learn about copyrights, so please enjoy our short production, and if you have any questions, just visit the Copyright Office at copyright.gov.
You've all seen the little circle R next to your favorite brand of coffee or tea, or at least the little tiny TM. These are indications that these names, brands, logos, and taglines are registered trademarks or considered trademarks and may be pending registration, respectively. Even if the mark is temporary and part of a campaign, like the Anthropologie Big A, or merely words like the Rifle Paper Company logo, it is considered a trademark. Trademarks help your potential clients and customers distinguish your products and services from your competitors. A good way to understand this is by taking a walk down any grocery store aisle. You can immediately recognize your favorite products versus those that you don't like. This is purposeful. These companies have spent hundreds of millions of dollars securing and protecting their trademark rights so that you can quickly glance at a bag of chips and know you've selected the right ones. This translates to your small business because, like a bag of chips, you produce something for sale, whether that's a physical or digital product or a service for your clients. In order to distinguish your offering in your industry, you may choose to develop your own trademarks, and if they are valuable enough to you, it's time to start thinking about registration.
Thanks, Christina. In general, patents protect people's ideas in the form of inventions. Outside of a few exceptions, patents can be obtained for any process, machine, article of manufacture, or composition of matter. This also includes any improvement to the previous categories. Now, a patent is not needed for inventors to practice their inventions. Patent owners obtain patents in order to exclude others from practicing their inventions. With a patent, patent owners can prevent any type of use by others, which includes the selling, making, and importing of the invention. However, there are some limitations. Patent owners' rights only extend to the invention as specifically claimed in the patent, the countries in which the patent owners have secured patents, and can only be enforced for 20 years. Now we turn to Sherrod for a brief look at trade secrets.
Trade secrets are different than other forms of intellectual property. Unlike with copyrighted materials, trademarks, or patents, a trade secret is a secret because the public does not know about it, although the public may use products derived from the secret. Two of the most popular examples of trade secrets are the Coca-Cola formula and the KFC chicken recipe. But not just big companies have trade secrets. Most companies have trade secrets, and they can be many things: a list of customers, a design specification, a pattern, a pricing list, or even a device. Every business should have a basic understanding of how to identify the trade secrets that give them a competitive edge, how to protect them, and what action they can take if a trade secret is stolen, for example, by a former employee.
Thanks, Sherrod. On behalf of all of my colleagues, thanks again for watching our video. If you found it informative, we invite you to watch the rest of the series. The remaining videos go into more detail on the categories of IP previously discussed, as well as some other areas of interest associated with intellectual property law. If you have any questions, please do not hesitate to contact the State Bar of Georgia or any of us directly.